Recording in progress.
Mrinal, you are not audible.
Good morning, everyone. Thank you to each and everyone for being here with us today. I am very pleased to be able to welcome you all here. Today marks our first webinar, and we are proud to able to host it today at this wonderful platform with you all. Well, before starting today's event, I would like to introduce the organization first and apprise you all about the main impetus for the event. Indian Legal Solution is a top-ranked law blog in India. We are a group of lawyers and law students across India providing a unique platform for law students to represent their talents in the field of law. We provide different free opportunities to law students. We provide free publication of research papers in our two journals, ILS JCCL and ILS IJLM. We are recognized by Startup India, Ministry of Commerce and Industry, and Government of India. Now about the event, being a law student, we all are aware about the significance of drafting a memorial for a moot court competition. This is so important as this is considered to be the foundation of advocacy. Arguing in the virtual court with the feeling of the original court. So we are organizing this webinar to guide you through the art of drafting of memorial. Well, I don't want to take too much of your time. I need to leave the stage for our speaker, Mr. Ishan Mishra. He is a core member of Indian Legal Solution and the trainer of our famous research methodology course. He is guiding students in research and drafting since 2017. Today will be full of learning. So a very warm welcome to each and every one of you. If you have any questions, stick to the webinar and write in the chat box. Over to you, sir.
Thank you, Mrinal. First, I would like to ask that I am Mrinal, am I audible?
Yes, sir, you are audible.
If anyone could please tell me whether I am audible and visible as well.
Yes, you are audible and visible.
Okay, thank you. So, good morning, everyone. Good morning, Sandeep. Before starting, I would firstly like to thank Mr. Raghavan for giving me this opportunity to speak on a matter which is extremely crucial, not only to law students, but also to advocates. So, without much ado, without squandering much of your time on the purpose of moot court and how it helps or how it bolsters our career or how in our speaking or rhetorical skills, I would directly move towards the content of memorial. So, what do we have? What do we really want to do when we are drafting a memorial? First, the contents is we have cover page, and then the table of content and list of abbreviations. Information regarding these three contents are easily available on Google, and they can be easily learned about by YouTube. So I would not be discussing in much detail, or I would not be going in meticulous details about these things, because nothing vast is in there. When you are drafting a cover page, all you have to do is to find out what is the kind of color we have to use for applet and respondent. Name of the parties is to be mentioned, name of the court is to be mentioned, under which jurisdiction you are applying is to be mentioned. So these informations are very easily available. I would directly like to move forward. What are the main ingredients? What are the main essentials of moot court drafting? So the next topic which I would like to discuss with you all is statement of facts. what is necessary, what all are the things which we need to keep in our mind while we are drafting our statement of facts. Because the statement of facts plays a very important role, because if judge is not clear what are the facts in which you are arguing, if he is not clear about the facts, how you will going to proceed with the case. This is very evident, this is very obvious. So whenever you are drafting your statement of facts, always keep in mind that put only those facts which are relevant. Don't put unnecessary facts that A and B are residing together and they are were in love and affection from since 2010 2011. There is no need to mention all those things, because no issue of law could be raised from these things. And if you think that your issue could be raised from these facts, then no doubt you should go for it. You should mention those in your statement of facts. Wait, my internet connection is unstable. Let me fix it. You people can hear me? Everything's fine? Okay. So where was I? I was discussing a statement of facts. After a statement of facts is being discussed, we need to move towards a statement of jurisdiction. However, don't take it in the chronological order and the moot court in the memorial. You have to, I guess, firstly mention a statement of jurisdiction and then a statement of facts. I am putting it on the basis of importance. So now comes the statement of jurisdiction. Whenever you are approaching to a court, whenever you are addressing a bench, it must be crystal clear in your mind that under which article or which section you are approaching the court, because court mostly ask what is the maintainability of your petition. So if you are not clear that under which article or which jurisdiction I'm approaching the court, your case is done there. No opportunity any further will be offered to you to argue anymore, because the court will say that, Mr. Counsel, simply because you don't know the under which article you are appearing, how can we concede that you are going to argue very well? So that's why whenever you are writing or drafting a statement of jurisdiction, while mentioning the article, if it is in Supreme Court, Article 136, or if it is under red jurisdiction, Article 32, you must know all the essential ingredients, all the essential elements of Article 136. That if I am going under Article 136, then why I am going in it? Why not under Article 133 or 134 or 135? It should be crystal clear in your mind. And let's suppose if it is an appeal before the High Court, you must know what are the all essential elements in Section 378 CRPC. And if it is a civil matter in the CPC, I think 99 or 100, you have to be extremely conceptually clear about what these sections really talk about. You must know all these things. I can still remind the fact I was last year. I went for a national moot court, and that moot court was in Rajasthan University. I was the counsel. So when I stood and asked the permission of the bench that your lordship, the council seeks your permission to approach the dice. These are all the basic formalities which we usually do in moot court, but not in actual court practices. So I said that and went to the podium. The bench asked me a question, Mr. Counsel, you come before to seek justice. I said, yes, your lordship. Then under which article you were appearing? I said that under Article 136, your lordship. And they asked me, why only Article 136? So I was aware of the fact that if we are going under Article 136, it's a special leave petition. And whenever grave injustice is being done or grave violation of law is being done, then you go under 136. So why I mentioned that? But then they ask, okay, Mr. Counsel, I agree that whenever grave injustice is done, you should come before us. Tell us in your facts that where grave injustice is done. I was very scared. I was getting embarrassed that I am not able to satisfy the court that I am coming before which article. I told the court that I am coming under 136, but I'm not able to satisfy them that where this portion of grave injustice is being done to me. I was scared. I said and got reminded by a fact that in our college we used to be told that if supposedly you are not able to answer a question, then you simply say that your lordship, the council pleads your ignorance. You know, these judges, are very acute, very sagacious in mind. Within a second, he said that, Mr. Counsel, there's a Latin maxim. Now, I was thinking, which Latin maxim? He said, ignorantia facit excusat, ignorantia juris non excusat. Ignorance of fact is excusable, but ignorance of law is not excusable. Then and there, I started sweating. My perspiration levels were very high. I said that, Your Lordship, please forgive me. Please, I don't want to settle my case here and there. Please listen to me at least for next three issues. So they, showing their magnanimity, they allowed me that, okay, Mr. Counsel. They even asked me that, Mr. Counsel, you are in which year? So I told them. So the moral of the story is what I want you people to learn from it, that whenever you are going for a statement of jurisdiction, it must be very clear in your mind that what are the all ingredients of the section or the article under which you are appearing. Now the statement of jurisdiction is being done, it is being drafted in your memorial. Then comes the second thing. What is that second thing? The second thing is summary of arguments. So I suggest that before writing, no, not before summary of argument, you have to deal with issues of law. I'll come to issues of law a bit later. Let me first discuss summary of argument. Summary of argument should always be after you have written all your argument at once. Once you have prepared or drafted your argument at once, then it becomes very easy. It becomes a cakewalk to write summary of arguments. Now coming to the main portion of the memorial, that is issues of law and arguments advance. Now the thing comes, how will you find out the issue, or how will you do the drafting of your arguments? So in order to take you there, I would like to share a very interesting method with you all people. The method is known as ILAC method. ILAC. I stands for issues, L stands for law, and A stands for application or implementation or appraisal of facts. And then the conclusion. Simply like when we were in our high school, we used to taught how to write an essay. We were required to write an introduction and main body and then conclusion. Exactly, this is also the in very flexible sense. This is also the technique to write your arguments, to frame your legal arguments. So starting with the first essential, that is of ILAC method, that is issues of law. How you are going to find out the issues? These days, in most of the prepositions, issues of law are being already mentioned. But what if issues of law are not mentioned? What you have to do is to find out all the relevant portion of the preposition. Once you are able to find out all those relevant portions, all those relevant facts, then you have to apply your judicial mind into it, and how you are going to convert those worldly facts into issues of law is totally something which which could only be learned from experiences. For example, let me take an example. Time is running very fast. Let's suppose Mr. A is driving his car, and while driving his car, he accidentally hit a pedestrian or a person on bicycle. So this is a worldly fact. Now we have to convert it or transposition it into a legal issue. How we'll do it? We will say that whether Mr. A was driving his car negligently. So this is the technique. This is a very basic issue. I took it to just simplify the matter. And if your issues of law, the more precisely, the more concisely, the more clearly they are framed, the better your arguments will to be. Now, once the issues are being settled, we'll go for the second ingredient of ILAC method, that is L, law. Once you have told the court that your lordship, that the honorable court, these are my 4 or 5 issues. Now it's the time to proceed for the second stage. The second stage is definitely the law. You will tell the court that what are the relevant provisions of the statute which are addressing these issues of law. You will tell the court what are the concerned piece of legislations, and then the precedents, the case laws. And while telling the court what are the law which is concerned with these issues of law, you must always try to clarify each and every aspect of law which you are putting before the court. If you yourself are confused that no, I'm not able to simplify or justify why I am putting or using this statute or this section for a particular fact, judge will know it. They will simply know it, and your case is done there. You will be confused, judges will be confused, and they'll simply ask you to, okay, Mr. Counsel, summarize your case and leave. So after issues of law being discussed, after law is being told to the court, you will move to the third step, that is A. A stands for application. Application or appraisal of facts means that while discussing law, you will tell the court how concerned facts apply to the particular law. If you have discussed a section, let's suppose you have discussed section 32 of Evidence Act, you will tell the court that, your lordship, how these 4 or 5 essentials of section 32 one by one are being met in the facts. And then you will proceed with the precedent, binding precedents. And also remember to mention facts of some landmark cases. Only mention facts of those landmark cases which are auspicious to your case, in order to lead them towards a conclusion that, your lordship, these matters or matters in dispute are being already settled by Supreme Court. And this is why I'm telling you all of this, because the facts of these case directly apply to my facts. This is what we call appraisal of facts. So you have told the court that, your lordship, these are the issues, these are the law, and this is the appraisal of fact. This is the implementation of law on my concerned facts. After you have done these 3 steps, the judge, the bench is pretty much clear in his mind that yes, this student or this counsel is eloquent. He's able to articulate his thoughts, his expressions, his mind, and he has prepared well. He is not impromptu before us. They will start taking interest in your matter. And once these 3 things are being settled, you will move towards conclusion. And in conclusion, we usually do is we take them back to the issue and tell them that, lordship, these are the law and these are the facts which I have already discussed, and how this my discussion of 45 minutes or 1 hour answers these issues of law. This is what I want to articulate to you all you people, that once these 3 things are done, all you have to do is to conclude your matter. So this is what ILAC method means. There are many other methods to draft your memorial, but because of devoid of time, I cannot discuss all those methods with you. This was the very rudimentary method in our course which we do or conduct. We discuss in great detail what are the other methods, how you are going to draft, how you are going to draft your prayers. We discuss in great detail, but because of shortage of time, I don't think I have that much of time to discuss all those things with you. So once your drafting is being done, I would also like to put forth before you 3 hard and fast rules of drafting your argument. These are very interesting. The one is, whenever you are drafting a legal argument, you must be backed by some legal authority. You cannot go to the court and say that, your lordship, this is what I think, your lordship, this is what I feel. To be very honest, your opinions, your views, your thoughts mean nothing to the court. You are no authority in yourself. So always keep in mind that whenever you are putting an argument before court, it should be backed by a legal authority. Second is that whenever you are addressing a law, or you are telling the court that this is the law, and you want to cite some sources, always use hierarchy of sources. Those hierarchy of sources which apply to the jurisdiction the jurisdiction under which you are applying to the court. This is very essential. Let's suppose, for instance, take an example. If you have approached Supreme Court, then what you will do? Will you cite directly cases of High Court, or will you cite directly the commentaries of Rajya Sabha? No. Hierarchy of sources is very much important. It's imperative. So you'll cite the piece of legislations, the statutes, and then the cases, and then the commentaries. And after that, if on that particular matter, writings or speeches of eminent jurists are available, then those things you have to cite. And the third one, the very important, I must say, the third one, which is very important, is that if there is any law or if there is any authority which goes against your case, you must not be shy of it. You should not be scared of it. You should have this much of audacity to accept before the court, to concede before the court that yes, your lordship, these are the provisions and these are the precedents which go against my case. And one by one, by applying your sagacious mind, you have to tell them how these matters or how these precedents or facts of that case don't apply here on my case. This is what you have to do while drafting your argument. And at last, I would like to share two strategies of researching. However, this is not very strictly related to drafting of memorial, but these two strategies really work while doing researching. What are those two strategies? First is um, first is that if there are, let's suppose, three issues of law before you, you divide all those three issues and give one issue to one person of your team. So there are three issues and three members, and all those three people will be having three different issues, and they will be researching one individual, one issue. They can research, and after a month or 2 months, they will be fraught of comprehensive and exhaustive information about on that issue. So this is the benefit of approach one. What is the second approach or strategy? You take all these three issues and ask your team members to research upon all these three issues. And the benefit of this approach is that whenever in a court of law, I mean, whenever in moot court, the judges ask you a question on a one particular issue, and if any one or two of you are not able to answer the question, I'm very sure that the third person must be able to answer it, because all three have issued have researched on all three issues. So summing up all my discussion before you with you, I would like to say that research prodigiously means to research in great extent. Research every aspect, be it political, social, jurisprudential, legal, or case law wise. Research prodigiously, draft efficiently and precisely. Because after you have done a prodigious, enormous research, you have too much of matter. But all those matter need not to be put it in your memorial. So research prodigiously, draft efficiently and concisely, and argue eloquently. This is the three things, and if you follow them, your argument, your memorial will be, I think, flawless. So that's all, Mrinal. I am done. I've concluded. So are there any questions which I would love to answer? Mrinal. All those who are having doubts or questions, they can write in chat box. I would be delighted to answer them. Was I this much clear that no one is having any question?
Sir, there is
Okay,
a
Koshki Sharma. Koshki Sharma is putting a question forth me that can you please explain again how to frame issues? Yes, Koshki, I can definitely answer this. Uh, all what you have to do is to find the relevant facts from your preposition. Once the relevant facts are being found out, you have to apply your judicial mind and think that how you are going to convert them into issues of law. Suppose the example I took, that if Mr. A is driving a car and he hit it by accidentally Mr. B, a pedestrian, you have to apply your mind that what offense or tort is this act is constituting. If you have read law of torts, if you have read IPC, you would come to know that this is negligence. And then and there you will be able to frame a issue of law in your mind that whether act of Mr. A is amounted to negligence, and what are the compensations to be allowed or favored. So this is the way how you are going to draft your issues. Difference between IRAC and ILAC method. I'm very sorry, Vinci, I don't know exactly what you are referring with IRAC. But let me go through my notes. I think it's issue, rule, application, and conclusion. When see rule is pretty much simple, pretty much akin to law. Rule here is pretty much akin to law. Next question is, yes, Shagun, Kashyap, a very intelligent question. That if you are approaching High Court, what should be the hierarchy of sources? If you have approached the High Court, you should first deal with the provisions of law, and after discussing the provisions of law, tell them about the cases of of Supreme Court, because ultimately all High Courts are bound by the judgment of by Supreme Court. If you are aware of Article 141 of our Indian Constitution, that says that all judgments of Supreme Court are binding on below High Courts. This is also known as doctrine of stare decisis. Kajal Chauhan, thank you, Kajal. Anshika Tripathi is asking what we have to mention in statement of jurisdiction. Anshika, all you have to say is that Honorable Court, I am approaching to you under this article. Let's suppose if you are preferring an appeal to Supreme Court, if you are going in a special leave petition, then you will mention that I am coming under Article 136. If you are going in appeal in High Court, then you have to mention the relevant sections of CRPC, and if it is of civil nature, then you have to mention the section of CPC. Dev Malya is asking me, is there any more method other than ILAC? Yes, Dev Malya, there are many more methods, but I cannot discuss with them here. We have our courses, very detailed courses on how to draft memorial, and there we discuss these things. Saujanya is asking me, sir, I have a small query regarding summary of arguments. What should be the main thing included in it? Then the arguments advance. Saujanya, I would suggest you that if you have studied in your high school Prezi writing, all we have to do was we have to precise it. We have to bring it in a concise form. So if your arguments advance are running into 5-6 pages, all you have to do is summarize them. There is no hard and fast rule that I can tell you. All you have to do is to apply your mind and concise them, and think that no argument or no important landmark judgment is missing from it. It should be in there in your summary of arguments. Redmi 123 is saying very well explained, sir. Appreciable. So please tell me how to go. Sakshi, what are you asking? So please tell me about citation and how to go about for it. Please elaborate your question. Please elaborate more. I'm not able to understand this. While you are framing your questions, I would like to tell you all of people that Indian Legal Solution has organized a very well detailed, a very well assiduous course on memorial drafting, in which I personally train or guide people who are interested in these courses. And there we discuss everything in very much detail. How to frame issues, how to draft your arguments, how to write prayers. I haven't mentioned the session of the concept of prayer in the session, because that requires especially some more time. And because there is devoid of time, I cannot discuss all those things in here within 30 or 40 minutes. Yes, Sakshi. In mode code, we have to cite by the word sources. I mean that we have to tell them that from where we are asserting or alleging these things. We have to tell them that, let's suppose if there was a dying declaration, we have to tell them that dying declaration is a provision which is already covered by under section 32 of Evidence Act. So this is what sources means. And you have to cite them. You have to write all of them in your memorials. Sections, explanations, provisos, all the relevant facts of landmark judgments, and then appraisal of your facts. You have to do it in your memorial. Nishtha is asking me what should be the length of memorial. What should be the length of memorial? Before answering this question, I would like to share a joke with you all people. My grandpa used to say that we lawyers are a person who used to write our arguments in thousands of pages and still call it a brief. So don't do that. Don't include too many pages in your memorials. It should be around, I guess, 30 to 40 pages. That's pretty much enough. Saurav Prakash, brother, I'm not able to understand your question. Please reframe it. Okay, there's a question that asks me, sir, how freshers learn to draft with all facts and law? What should we do? Okay, Sandeep, this is a question asked by you. Sandeep, we will have a very detailed discussion on it when we'll meet, but still, I would like to answer it here. When the freshers are really interested in moot court, all they have to do, at least in first year, they should read and try to grab complete and a decent knowledge of substantive law. Once their knowledge of substantive law is acquired by them, then automatically they will learn how to draft it, because the concept of substantive law is cleared, and then after you move towards procedural law, and procedural law is also cleared, substantive law is also cleared, automatically you come to know how to frame arguments. For example, let me take an example. If you have read CPC order 7 talks about plaint. So if you have completely grasped the knowledge of how to draft the plaint, how to put forth the contentions of your in the plaint, you will ultimately know it. However, these things are to be discussed in very great detail. I cannot discuss it here. No more questions? Okay, thank you. Thank you, Racy. Mrinal, where are you?
Sir, thank you, sir. Actually, there were network problems, so I got disconnected when you were calling my name, taking my name.
Okay, Mrinal, no problem, no problem. So shall I take your leave, Mrinal?
Yes, sir. Thank you very much for enlightening us with your knowledgeable informations.
Okay, Mrinal. Thank you, brother. I'm taking your leave. Thank you, Mr. Rangvind. Thank you.
Thank you, sir.
Bye.
Thank you.
So thank you, everyone. We appreciate you being here. Thanks again for joining us today, and we will see you next time. Hope you all had a knowledgeable session. Thank you.